Let's begin here. President Cyril Ramaphosa's legal team is in communication with the Public Protector's Office on the way forward. On Tuesday, the Chapter 9 institution announced that it would not be affording the president another extension to respond to questions on the Phala-Phala saga. In a statement, the office announced that the president missed the deadline again after it had granted him an extension earlier this month. Now it remains to be seen whether the president will submit his response to the Public Protector's Office or if the institution will have to subpoena him. Let's look at this with Nthabiseng Dubazana, who's a legal analyst. Thank you so much for your time, Nthabiseng. Another mixed extension. Did it take you by surprise?
It did. Well, maybe not. Let me not lie. When we look at the way that things have been going, it was a situation whereby, remember, just when the 31 questions were issued, the president suspended the then public protector, thereby absolving him, so to speak, from answering those questions in quotes because the office still stands. And then now we're at a situation whereby the public wanted to know whether or not the president will be answering now that the Swim Kwebane has now been suspended. I think that it was prudent for the Office of the Public Protector to make that statement to say that the answering still has to happen regardless of who is sitting at the helm of the Section 9 institution. So they had given him an extension the first time. It was clear, in my opinion at least, that by suspending the then Public Protector, he was not going to answer the questions by the deadline. And then he was given an extension which he missed as well. So at this stage, asking for a second extension or postponement for him to answer the said questions was pretty obvious. And now waiting to see whether the public protector will actually issue a subpoena is where we're at now. I'm hoping that it doesn't get there, but by the looks of things, it might just get there where the issuing of the subpoena has to be issued in order for him to answer the said questions.
Do you think, though, that the issuing of a subpoena could guarantee the answers that the public protector is looking for here?
Probably not. A subpoena, it's a legal document ordering you basically to come to the court, if it's in a court situation, and answer to certain allegations that have been leveled against you. Once you get there, you may raise any sort of issues that that you cannot answer this because of that, and then the matter can be postponed. That is in a court setup. But in this situation, whether or not the public protector will afford Ramaphosa the opportunity to have the matter postponed based on whatever allegations or reasons that he will raise, saying he cannot answer those 31 questions as yet because he still needs information from the police, for example, or he needs information from the people who were present at the house when the robbery happened, etc. These are things that will have to be discussed between the legal team of Ramaphosa as well as the Office of the Public Protector, and for them to make a decision on how to go forward thereafter.
And they are, in talks, as his lawyers say, that they're speaking to the office in order to see how, a way forward can be charted here. In your view, what needs to be the way forward, and one that could even bring some kind of finality to this matter, or even satisfaction for those who are saying that they're waiting to see how this one unfolds?
I think based on the immense public interest in this matter, the way forward has to be one that at minimum gives us a little bit of a glimpse into what actually happened on the day at the Phala-Phala farm, and also giving us some direction on how the investigations are going to go after those 31 questions have been answered. Because right now it's just a matter of giving the, in quotes, the accused or the person who's these questions are being labeled against, an opportunity to answer them before we dig deeper as Section 9 institution to find out these answers on behalf of the public. So if we do not get any clarity, the Office of the Public Protector may just be forced to ask help from the courts in order to get this information because of the immense public interest within this matter.
And listening to the African Transformation Movement, who are the complainant, in this particular matter, they say that they are not convinced that should things get to a subpoena stage, that this would be an effective strategy to hold the president to account. Does the public protector, though, have any room to avoid this at all, in your view, should things not go the way she wants? Or are there other mechanisms, because they seem to think that there is more that can be done here in order to hold the president to account?
Well, I think the Public Protector's Office is actually doing it correctly by following procedure. We don't want a situation whereby she jumps certain steps and then tries and follows the other procedures available to her. And then when it gets to the court says, but wait, why did you not do 1, 2, 3, 4 before jumping to 7, 8, 9? And then we're back to where we are right now. So the strategy, I believe, at least I hope, is that the Public Protector is trying to make sure that they follow procedure to the best way that they can. So by the time this matter ever gets to court for lack of information coming from the president, therefore they can show a trail of evidence showing that they had attempted to do this, when this failed they did that, etc., which left them with nothing else other than to approach the courts for assistance.
How would you say the president has fared in his handling of this particular one? Because, you know, when journalists, for example, are asking the questions, he says he will answer through, you know, the various structures that are, you know, investigating this particular matter, while others are saying that, but he should be, you know, speaking and holding, in fact, taking the nation into his confidence. It doesn't matter that this is a legal process, but there are ways to go about this. What do you make of his handling of this so far?
Well, I think perhaps he's getting instructions or information from his legal team on how best to handle this matter. Unfortunately, it is a legal matter. There are certain things you can divulge and there are certain things you can't divulge. Just because he's the head of state and just because he is supposed to take us into his confidence based basically on, let's say we look at the rationale of the ANC, I believe it is, whereby if you're accused of certain misconduct, you're supposed to be handled in a certain manner. I think that is the way in which the public is looking at it, saying that however your ministers have done this and as a result they've been suspended, etc., why are you not following the same suit? So I think now the way that he's handling it, he's choosing to let the attorneys instruct him on how best to respond to these questions. And then he's choosing to also see how best to get out of it without having to taint his name as badly as it seems in public it is tainted. But we don't know per se in the document and the actual legal case itself how bad or even how non-existent his name is involved within the actual case.
If we can change gears slightly and go to Parliament, it's another Public Protector's Office, process that is now unfolding, of course, albeit in Parliament. The lawyers of Advocate Busisiwe Mkhwebane are saying that they may have to compel the president to come and to, tell the inquiry why he suspended her, although the president is adamant on the same breath, saying that he did not suspend her because she did something wrong, but to make way for this parliamentary committee's proceedings to go ahead. How do you see this one playing out?
When I look at the first 2 days of the inquiry, which is the one I was actually following, unfortunately I didn't follow for the past 3. But when you look at the way that they were trying to set up the inquiry or the commission, they were trying to say that the Public Protector, Subpoena Mkhwebane, should not have been suspended and be sitting here as an active Section 9 institution head, so that these questions are leveled at somebody who's actually sitting in that position. There was a lot of debate, some for her being reinstituted, some were against. So I think I understand the way in which the attorneys for Advocate Subpoena Mkhwebane are saying that he should come and explain, because he suspended her prior to a court order, which obviously gave him the green light at the end of the day. But we hadn't had information of that at the time of suspension. So it's giving us a question of saying, why would you do that immediately after getting 31 questions to answer? Then you decide to suspend, and then a court order confirms your order. Why would you do that? It's falling within the realms of a possible illegal move, which is what the attorneys for Advocate Subpoena Mkhwebane are advocating for. So we will see how that one works. It will be interesting to hear the outcome of that one.
All right. Thank you so much for your time. That was legal analyst Nthabiseng Dubazana.